great to be here, and thank you, Jeff. And I'm very excited about Peter's presentation. But I am Lisa Rosenthal with ACE by TSK. We are a CEU provider with the state of Florida for CAMs. And we have an organization that supports these kinds of conversations on a regular basis, both in-person breakfasts along the East Coast of Florida, South Florida, in both North Palm Beach, Delray Beach, and Pompano. And so we have in-person breakfasts every month in all three of those locations. And we're so excited to also be able to present online programs like this one and many to come still. So thank you all. If you are not getting our emails directly, we'd love for you to follow us. And you can go to acebytsk.com to receive our emails. And we're also on LinkedIn and Instagram if you'd like to follow us. All right. So again, thank you, Jeff and Peter. So good to see you and so excited about this presentation.
So without further ado, I'd like to now turn it over to our main event of the day. He is from the Kaye Bender Rembaum Palm Beach Gardens location, one of the few board certified specialists in condominium and plan development law in the state of Florida. We're privileged to have him today. It's Peter Mollengarden, again from KBR at the Palm Beach Gardens office. Peter, take it away.
Thank you, Jeff, and good afternoon, everyone. When he says main event, it sounds like a boxing match. Hopefully that will not be the case.
Hopefully not.
But thank you and welcome. Today's presentation, as Jeff mentioned, is the Homeowner Association Board Member Certification course. So this is for new board members or those board members who are coming back onto the board, as Jeff mentioned, managers or anyone who's just interested in an overview of Homeowner Association law and provisions. As Jeff mentioned, I am with Kaye Bender Rembaum. I am as he mentioned, a Florida Bar board certified condominium and plan unit development specialist. I have been practicing in this area since 1984. So it's been a couple of years. Most of that practice in the South Florida area, most of that practice representing associations. In a prior life, I did represent developers in the Silver Spring, Maryland area, outside of Washington, D.C., where I used to write condominium and HOA documents. But for the bulk of my career, I've been representing associations. And the firm, that's our concentration, is to represent associations throughout Florida. So without further ado, we're going to start with this course. As Jeff mentioned, it is a long course. I may not get to all of the slides. Some slides I may skip over. That's okay. Don't worry. I will try to get in as much information as I can. Now, what I am going to do, although this is an HOA board member course, I am going to make some comparisons with the homeowner association law and the condominium law. Not that I'm trying to teach the condominium board course here, but just because I think sometimes there's a lot of confusion out there between HOA and condos with respect to the law and what covers each. So sometimes I do like to mention the differences. I think it kind of highlights things for those listening as far as, the things they have to concentrate on between HOA versus condo. Okay, to move on. Why are we here? As we just mentioned, you're here because within 90 days under Florida law, within 90 days after being elected or appointed to the board, or within 1 year before coming on, or within 90 days after, a board member must satisfactorily complete an educational curriculum, which is administered by the division with an approved education provider, such as myself, okay? Or you can certify in writing to the association, to the secretary, that you have read the documents, the declaration, articles, bylaws, and written rules and policies. We'll work to uphold such documents to the best of your ability, and will faithfully discharge your fiduciary responsibility to the association members. That takes about 10 seconds to do, as opposed to this course, which takes 2 hours. But I think in the course, I think it's more beneficial in terms of actually learning things about HOAs that you'll need to know in your tenure or on your tenure as a board member. So, as I was trying to say,
sorry about that.
It's okay. If you fail to become certified or fail to sign the certification, then you're suspended from the board until you have fulfilled that certification. You do not have to repeat being certified so long as you serve on the board uninterrupted. So whether that's 3 days or 3 years or 10 years, you don't have to repeat it. Well, it may be helpful to do so. The association has to keep your certification or your educational certificate for at least 5 years, okay? Or for as long as you serve on the board uninterrupted, whichever is longer, okay? But it's a minimum of 5 years. Now, if a board member has not become certified, like I said, they are suspended, but any decisions that the board makes while that board member is sitting is not affected. So the fact that a board member is on the board, making decisions, voting, whatever, those decisions are not affected by the fact that he or she may not have been certified.
Okay, we're on the title page, chapter 720, Florida statutes.
Well, I'm not, but. All right, so now yours is, okay, now I'm on the title page. All right. All right, next page.
Page 5.
Okay. Now, there are certain differences between an HOA and a condominium. An HOA exists without any enabling legislation. In a condominium does not exist unless there's a condominium act that allows people to own property in that manner because they're owning airspace. HOA, though, are common law. In fact, for many, many, many years, there was no HOA statute. It only became in being back in the 90s. In a HOA, the association owns the common area. In a condominium, the association does not own the common elements. They're owned by the owners and shares. So those are the basic distinctions between HOA and condo. There's more, but remember, condominium, creature of statute, owning airspace, common elements owned by the owners. HOA, common law, common area, almost always owned by the association.
Page 6.
Okay. The Homeowner Association Act is Chapter 720. Okay. Chapter 720 applies to homeowner associations. Chapter 718 applies to condominium associations. It basically gives statutory recognition to corporations that operate residential communities. It does not apply to communities that are primarily intended for commercial, industrial, or other non-residential purposes. It provides procedures for the operation of an HOA, of a homeowner association, and it is intended to protect the rights of the members without basically undue impairment of the ability of the association to perform its functions.
I'm on 7.
Okay, now which version of Chapter 720 applies? This is something called the Kaufman language. The Kaufman is something in a condominium. I'm not going to get too deep into this. Just basically be aware that the version of Chapter 720 that applies to substantive issues is the version of Chapter 720 that was in effect when your declaration of covenants was recorded, unless the declaration says it's subject to Chapter 720 as amended from time to time. In that case, substantive vested rights will also be applicable. Substantive provisions of Chapter 720 will be applicable, whereas procedural matters apply retroactively. So the procedural matters of Chapter 720 regarding meeting notices and things like that, they apply notwithstanding when your declaration was recorded, but more substantive issues dealing with things like voting rights, perhaps, typically they will only apply if your declaration, new things will only apply if your declaration has language saying you're subject to Chapter 720 as amended from time to time. This is basically a constitutional provision because under the Florida Constitution, laws that are enacted, let's say today, cannot impair existing contracts. Okay, a declaration is a contract. So that's why it can't impair existing vested rights under that declaration unless it's subject to those changes as amended from time to time.
All right. Page 8.
Again, which version applies? Generally speaking, it's the version that was in effect at the time that the HOA was created. Procedural laws, they will apply retroactively. Okay, substantive generally do not, unless it's clearly that they apply retroactively. And even then, sometimes you have to go through court cases to figure out whether or not it really truly does apply retroactively.
Okay, we're on 9.
Now, there's another statute you must be aware of, and that's Chapter 617. Chapter 617 is the Florida Corporation Not-for-Profit Act. Your corporation most likely is a not-for-profit corporation. By the way, that does not mean tax exempt. That just means not-for-profit in that profits are not distributed to the members. In the event of a conflict between Chapter 617 and Chapter 720, which is the Homeowner Association Act, Chapter 720 will prevail. But sometimes we do have to look to Chapter 617 because there are issues that Chapter 720 doesn't address. And in that case, we do have to look to Chapter 617 as well as the articles and bylaws of your association and read them all together.
Let's do this. You tell me where to go. And by
Next.
that, I mean pages.
Okay, page 10.
All right. Because I know you're going to skip around a little bit.
Yeah, I'll tell you now. Okay. In the event of a conflict between your declaration, articles, and bylaws, and I'm going to throw in rules, next page. Oops, even I went too far. Basically, the hierarchy is declaration of covenants is your number one document. Next is the articles of incorporation, which creates the corporation, then the bylaws, which is the procedural document, and finally, even though it's not on your screen, the rules and regulations, which are enforceable, but in the event of conflict, they're the caboose, so to speak. They're the fourth document in the hierarchy. However, you don't just throw up your hands. You try to read the documents together if possible, so there isn't a conflict. But if there is a direct conflict, say between the articles and bylaws regarding how many people serve on the board, or what's the eligibility requirements to serve on the board, then the articles will control over the bylaws. And again, like as it says, the declaration will control over the other two in the event of a direct conflict. All right, next.
Okay.
Now we're going to talk about transfer fees and estoppel certificates. Next.
Yep.
As a matter of policy, what's a transfer? A transfer fee is a charge that an association may make with respect to the sale or other conveyance of a lot or a parcel. They're not favored in the law. However, under section 689.28, in the event that your declaration of covenants sets forth a transfer fee or a charge upon the sale or other transfer, it would be enforceable, but it needs to be set forth in your declaration of covenants, not in the rules, not in the articles, not in the bylaws. Now, for condominiums, I said I was going to mention this every now and then. In the condominium statute, there's a very there's an express provision that limits how much an association can charge on the transfer, and it's called the transfer fee. And you're limited to $150 per applicant. In the HOA context, we don't have that limitation. So basically, the declaration can have a capital contribution fee or a transfer fee upon the sale or the resale of a home, of a lot. But as I said, must be set forth in your declaration of covenants and restrictions. Next. Now, estoppel certificates are very important. And what is estoppel? Estoppel, legal term basically mean reliance or detrimental reliance. What's an estoppel certificate? That's basically when a home is being sold or perhaps being refinanced, then the buyer or the mortgagee or the title company will request certain information from the association regarding the parcel. And this is set forth in an estoppel certificate because the buyer, mortgagee, whoever, can then rely upon this information. All right. So under the statute 720.30851, within 10 business days of receiving a request, written or electronic request for an estoppel certificate, you must basically provide it. Okay. The association must designate, on its website, a person or entity with a street or email address who will basically accept receipt of these requests. The certificate must be completed by a board member, an authorized agent, or authorized representative of the association, including any authorized agent, representative, or employee of the association's management company. And the certificate must be provided by hand delivery, regular mail, or email on the date of issuance. And it must be signed by an officer or authorized agent of the association. Next. What goes into the estoppel? Well, the date of issuance, the name of the lot owner, as shown in the books and records of the association, the property designation and address, if you have any parking space designated to or assigned to the parcel. If the lot is in collections, if it's delinquent, you have to have the attorney's name and contact information. The fee for the preparation, we'll get to the fee in a few seconds, and the name of the requesting party. Next. This is the real meat, which is the content of the estoppel with respect to the assessment information. The estoppel must disclose or contain the amount of the regular periodic assessment levied against the property and the frequency. So if the homes are assessed on a monthly basis at X dollars per month, that has to be disclosed here. Then number two, the date that the regular periodic assessment is paid through. So this lot, this home is current through whatever that date is. The date the next installment of the regular periodic assessment is due, whether that's monthly or quarterly. Okay, how much and what's the due date? Fourthly, an itemized list of all assessments, special assessments, and other monies owed on the date of issuance. This is crucial. So basically, what is owed, okay, as of the date of issuance, what is delinquent basically on this parcel, on this lot, as of the date that the certificate, the estoppel certificate is being issued. And also importantly, 5, an itemized list of any additional assessments, special assessments, and other monies that are scheduled to become due for each day after the date of issuance for the effective period. And we'll talk about the effective period in a second of the estoppel certificate. In calculating that amount, or the amounts that are scheduled to become due, the association may assume that any delinquent amounts will remain delinquent during the effective period of the estoppel certificate. Next.
Okay.
What else goes in there? If there is a capital contribution fee or a resale fee, remember we mentioned a few slides ago that your document, your declaration can authorize that, that must be disclosed and how much. Now, secondly, whether there's any open violation of a rule or regulation or of your declaration, notice previously to the owner of the property in the official records. Why is this important? If there's an open violation with respect to this home, let's say, for example, an architectural violation that the prior owner has been written to about by the association, that needs to be disclosed. If it's not, the new owner can basically say, hey, you didn't tell me about it, didn't realize this was a violation. I really love the fact this house is pink, blue, and orange, and if that pink, blue, and orange was actually a violation, then that needs to be disclosed. Otherwise, the new owner can say, hey, you've waived it because it wasn't that violation was not set forth in the estoppel. Thirdly, whether the rules and regulations, or not just the rules, but the declaration also applicable to this property, requires approval of the board of the association for the transfer, and if so, whether or not the board has approved the transfer. Is there a right of first refusal provided to the members or the association? And if so, whether or not the members have exercised that right of first refusal, meaning that the right of first refusal to basically purchase the home on the same terms and conditions as offered to the buyer. You have to list, you have to set forth the list and the contact information for all other associations for which the owner is a member. So if there's a master association, you have, or maybe even 2 associations, if it's some kind of multiple association community, and you have to be members of all the associations, these other associations must be listed as well as contact information with respect to those associations. You also have to include the contact information for all insurance that's maintained by the association. Usually that's through the contact information for the association's insurance agent. Next.
Okay.
We mentioned fees, right? If the unit, or if the home, lot, parcel is not delinquent, the association can charge $250 for the preparation of the certificate. Okay. If it is delinquent, if the lot is behind in payment, the owner is behind in payment, you can add another $150 to the fee. If they need it on an expedite basis because the closing is happening right away and they need it, they need the certificate right away, then if an expedited one is requested and it is delivered within 3 business days after request, there's an additional $100 fee you can add. Now, the board needs to adopt a resolution in order to charge the estoppel fee, and this authority must be set forth in that resolution or provided by a written management, bookkeeping, or maintenance contract. Let's say the association does not provide the estoppel certificate within the 10 business days after its request, after receipt of its request. In that event, then the fee cannot be charged. So the penalty for not providing the estoppel fee timely, the estoppel certificate timely, is that you cannot charge the fee that we just mentioned. Next.
All right.
If the sale or closing or the refinancing does not occur and no later than 30 days after the closing date, the preparer, meaning the association, most likely receives a written request accompanied by documentation. If the sale did not occur, then the fee must be refunded back to the person or the party that paid it. Okay. Now that refund is the obligation of the current owner. All right. And you can collect that. So if the association, did the work, charged the fee, but now has to pay it back, you can actually collect that money from the owner of the lot, and that's collectible in the same manner as an assessment, meaning it's secured by the association's lien authority. Next, we mentioned the effective periods, and this is very important. If you deliver the estoppel by hand delivery or email, it's effective from 30 days from the date of issuance. If it's sent by regular old-fashioned mail, snail mail, regular mail, then it's effective for 35 days to take into account for the mailing time. Right. If you know you made a mistake, if there's an oops in the estoppel certificate, and you realize that within the effective period, you can issue an amended one prior to the closing for which it was issued. And if so, it's good for another effective period of either 30 or 35 days, depending on how it was delivered. You can't charge a fee for that amended estoppel, but if it's inaccurate, it's important that you at least try to get out an accurate one, because if you look at the very bottom of the screen, and I'll just read it, an association waives the right to collect any money owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies upon the estoppel certificate and from the person's successors and assigns. So as I mentioned, estoppel means basically a lot reliance or detrimental reliance. So if you fail to indicate that this lot or parcel is delinquent, or fail to indicate how much it's delinquent, or you make a mistake as to how much it's delinquent, or if you fail to indicate that there's a special assessment coming due in the next 30 or 35 days, depending on the effective period of your estoppel, which depends on how it was delivered, if those things are not disclosed, for example, they will not be collectible from the new owner, because that new owner relied upon this. So it's very, very important that the estoppel be accurate with respect to, what is the financial obligation or obligations of this lot in terms of, is it delinquent and what is coming due in the next 30 or 35 days, because failure to include it means you lose it. And I'm not trying to be poetic there. Next. Okay. If you are requested or if you're asked to provide other information in addition to what goes into the estoppel certificate, you can provide that information. You're not required to, but you certainly can. You can also charge for it. Okay. The fee, though, cannot exceed $150 plus the cost of photocopying and any attorney's fees. Why is it attorney's fees? Because sometimes the questions they're asking really are better suited for the association's counsel to respond to rather than the board or the management agent, but you can charge the party who's requesting it for those attorney's fees on top of the $150 in the copying charges. Next.
All right, members meetings.
Oops. What did I do? Members meetings. Okay. And I'm on slide 22.
Yep.
All right. Every year you have an annual meeting, or you should. Okay. It may be the only membership meeting that you have. Many associations don't have more than the one membership meeting as opposed to board meetings. Okay. Because the election of directors must be held at or in connection or conjunction with the annual meeting. Now, you can also have special members meetings, which are meetings of the membership in addition to the annual meeting. Okay. When are those held? Well, typically they're held when called by the board of directors, or when at least 10% of the total voting interests petition for it, unless a different percentage is set forth in your documents. And typically your bylaws will have a section regarding membership meetings and special membership meetings. And in that section, typically it'll refer to what number or percentage of owners may request in writing a special membership meeting. In that case, you have to follow that provision. Next.
Okay.
If the bylaws do not provide for giving notice to members of member meetings, okay, then you must give at least 14 days notice. Most bylaws do have a provision for the membership meeting notice. If it's less than 14, I would give 14 days notice at a minimum in writing. Now, evidence of providing the notice must be made by an affidavit executed by the person providing the notice on behalf of the association. That must be kept among the official records. Okay, you must mail that notice of the meeting or have it delivered to the address identified as the owner's mailing address in the association's official records. Or if the owner has consented to electronic transmission, meaning email, then you can send it to that owner's email address, but he or she must have agreed in writing to receive notice of meetings electronically. Otherwise, they get it by regular hard copy. All notices must have the date, time, and location of the meeting. Now, the association by rule can adopt a procedure for posting that on a closed circuit cable television system. And if you're broadcasting it, you have to broadcast it, the notice and the agenda in a manner and for enough time to allow an average person to observe it, read it, and comprehend it. I would advise most associations that I'm experienced with do their notices in writing. Next.
All right.
The agenda. Now, unless the governing documents provide otherwise, okay, statutorily, the notice of annual meeting does not have to have an agenda or a purpose. However, I strongly advise you do so anyway. Okay, but check your documents. Your documents may require it, but even if they don't, in my view, our view, it's advisable to do so. For a special membership meeting, it's limited to the purpose or purposes described in the notice, and thus a special meeting, a special membership meeting must include a description of the purposes or purposes set forth on or in the agenda in the notice. Next.
All right.
Now, owners have a right to attend all the membership meetings and to speak on all agenda items and all other items that are open for discussion at the meeting. Notwithstanding anything in your documents, you must provide an owner at least 3 minutes to speak on each item, whether agenda item or other items that are brought up for discussion at the meeting. You can also adopt written reasonable rules governing the frequency, duration, and manner of owner statements. Obviously, those rules must be consistent with what we just said, meaning that they have to be able to, at a minimum, be allowed to speak for 3 minutes on all the agenda items or other items that are brought up. Interestingly, with an HOA, this is not a condominium provision, this is an HOA provision in the statute. Membership meetings must be held at a location accessible to those who are physically handicapped if it is requested by someone who is physically handicapped who has a right to attend the meeting. Interestingly, that's not in the Condominium Act, but it is in the Homeowner Association Act. Next.
Right.
What's a quorum? A quorum is the minimum number of members who must be represented at the meeting to conduct business. This is another difference between HOA and condo. In condo, that minimum numbers, that number is a majority unless your documents have a lower number. In an HOA, unless a lower number is set forth in your bylaws, 30% of the total voting interests of your owners constitutes a quorum at members' meeting, at a members' meeting. Generally speaking, the people who do what I do, we've all kind of reached a consensus years ago that even if your declaration has a quorum of a majority, that the 30% in the statute will control. There's no case on this. You can argue it goes the other way, but that's generally been how it's been looked at, that the 30% will control. Now, your documents could have a lower percentage. When I used to write documents for a living, I used to put 10% minimum quorum, which was very low, but statutorily it's 30%, again, unless your bylaws have a lower number. Now, unless otherwise required by law or in your documents, decisions requiring a vote of the membership, i.e. a vote of the owners, require the concurrence or the approval of at least a majority of the voting interests present in person or by proxy at a meeting at which a quorum has been obtained. So in other words, if you're voting on something that needs this type of approval because the documents don't require a greater approval, like a 75% of all or something, or 2/3 or something like that, then the vote that's needed to approve something will actually fluctuate. It will depend upon how many owners are represented at the meeting in person or by proxy, provided that a quorum is obtained, because it's a majority of that number. So whatever that number is, it's a majority of that. Like I said, that number can fluctuate, but at a minimum, you have to have a quorum there to conduct business. Next. Proxies. Huge difference in proxy voting in condos and HOAs. Some of you may be aware, in a condominium, for substantive matters, you can only vote by proxy, but what's known as a limited proxy. That's not the case in a homeowner association. Okay. In a homeowner association, unless otherwise provided in the governing documents, members have a right to vote in person or by proxy. That includes a general proxy. What's a general proxy? A general proxy is one in which I, as a homeowner, for example, give my proxy holder my proxy to represent me at a meeting, and that person that I designate can vote any way he or she wants on my behalf. A limited proxy is I have to direct them how to vote on the face of the proxy. As I mentioned, in a condominium, you can only vote by limited proxy. That's not in the Homeowner Association Act. Procedurally, for a proxy to be valid, it must be dated. You have to have the date, time, and place of the meeting, dated as in the signature must be dated, and it must be signed by the authorized person for that lot who executed the proxy. It's effective only for that meeting. However, a proxy expires 90 days after it's given. So although it's effective only for the meeting for which the date, time, and place is set forth on the proxy, if that meeting gets, let's say, adjourned to be reconvened at a later date, and that later date's within 90 days of the original date, that proxy is still good for the reconvened meeting because it has a 90-day life from the date of the meeting for which it's written or for which it's been provided. Now, a proxy is revocable at any time by the person who executes it. So if I give a proxy to someone and they say, you know what, I don't want them to have that proxy, or I'm going to show up in a meeting, I can, in writing, issue a revocation and revoke that proxy. If the proxy has substitution power, that means that the proxy holder, let's say I give my proxy to someone and he or she cannot make the meeting for whatever reason. If it has substitution power on there, then the proxy holder can substitute someone else to be the proxy holder. But that has to be on the face of the proxy. And a proxy basically is good if it's a copy. It doesn't have to be the original. So a facsimile or a scanned copy of a signed proxy is proper and effective. Next. I already mentioned general versus limited. Now it's on the screen. As I mentioned, general means proxy holder can vote however they want. Limited, it's directed. For a homeowner association, you got to check out your bylaws, that or your articles. That will basically indicate what type of proxy, if any, you can or can't use. Most HOA documents that I've read allow general proxies, but not always. Some, either as originally written or as amended, limit use to limited proxy. So you have to look, you have to check it out to see what type of, now occasionally you see documents that don't allow proxy voting. It's not that usual, but you have to look. So long story short, if it's silent, general proxies can be used. Otherwise, you know, if there's restrictions, they need to be set forth in the documents. In any event, both a limited or a general, depending on which one you can use, both can be used to create a quorum or establish a quorum. Next. Elections. Also a huge difference here between HOAs and condos, and I'm going to try to touch on that. Because I see a lot of confusion out there when I see how meetings are set up. I'm going to mention this first. In a condominium, it's basically all governed by Chapter 718 and the Condominium Act, and you follow that, which pretty much for the most part overrules any differences that are in the bylaws. HOA, it's pretty much the exact opposite. In a homeowner association, pursuant to the Homeowner Association Act, election of directors must be conducted in accordance with the procedure set forth in the governing documents, which usually is in the bylaws. Okay, and except for one exception, a quorum of members must be established in order to conduct an election and any other business of association at annual meeting. This contrasts again to a condominium. In a condominium, you don't need a quorum to conduct an election. You only need 20% of the eligible voting interest voting. That's not the case for an HOA. In an HOA, you got to follow your bylaws, and you have to have a quorum with one exception that I'll mention. Okay, and directors are elected by a plurality of the votes unless otherwise provided. So plurality means who gets the most votes. Not necessarily, you don't have to get a majority of votes. You have to get who gets the most votes. Who's eligible? Okay, basically, any member of the association, which is typically a unit owner or a lot owner, any member is eligible unless otherwise disqualified. If you're delinquent in the payment of any monetary obligation, for a condo, it's assessment, but here it's any monetary obligation to the association on the day that you can last nominate yourself to be on the board, then you cannot seek election. Now, what's that last day that you can nominate yourself for a homeowner association? That depends upon your documents. Okay. If you're allowed to take nominations from the floor, which you cannot do in condos, but you can in HOAs, depending on the documents, then that's the last day. If you have a pre-nomination process in the bylaws that sets a deadline for submitting your name, then that's the last day. So whatever it is, that last day that you can nominate yourself, if you're delinquent as of that day, you're not permitted to be elected. If you're convicted of a felony, okay, you're not eligible to serve unless your civil rights have been restored for at least 5 years as of the date you're seeking to be elected. Anyone who has a pending criminal charge for felony theft or embezzlement involving association funds or property, they're also not permitted to run or to be elected. The term, unless the bylaws provide otherwise, directors serve for a 1-year term, but in many documents, the directors will serve staggered either 2 or 3 year terms. So it's another area that you have to check out. Next. Now, I mentioned I was going to keep going through the contrast between condominiums. Election day, nominations from the floor. If the election process set forth in the governing documents allows candidates to be nominated in advance of the meeting, the association is not required to allow nominations at the meeting. Now, here I see a lot of missteps here, okay? Because, in a condominium context, since the early 90s, it was 92, and that statute got amended, if I recall right, or 91, nominations from the floor are not permitted in a condominium because they have a statutory pre-nomination process. That's not the case for an HOA, even though over and over again, I see HOAs copying the Condo Act, even when their documents don't call for it. In an HOA, like I said before, you must follow your bylaws. If your bylaws have a pre-nomination process, in other words, where people who want to serve on the board are required to submit their name a certain number of days in advance, then you don't have to have nominations from the floor because you have this pre-nomination process. But if you do not have that, and you have what I call the old-fashioned type of documents, HOA documents, which are not that old-fashioned because you see it a lot, which just says, the board will consist of so many directors and they're elected at the meeting without a lot of detail, that means that nominations then must be allowed from the floor. Again, so as I said 16 times already, I guess I'll say it 17 times, you have to follow your documents. And I think it's on the next slide, so I might be mentioning this twice. In a condominium, you can't use proxies in the election process. In an HOA, you definitely can, unless your bylaws say you cannot. Okay, so completely different. In a homeowner association, proxy voting is allowed for election of directors unless the bylaws provide otherwise. Completely different from condominiums. Now, an election is not required unless more candidates are nominated and vacancies exist. All right. If an election is not required because there are equal or fewer number of candidates, qualified candidates, than vacancies exist, and if nominations from the floor are not required, then they're automatically seated regardless of the quorum. So this is the one exception where you don't need a quorum for an HOA election, which is where you have an equal or fewer number of candidates. There's no nominations from the floor because you have a pre-nomination process. So you have a 5-member board and you have 5 or fewer candidates. There's no nominations from the floor because of a pre-nomination process in your bylaws. In that instance, you don't have to have a quorum to have those candidates be seated. Otherwise, for an HOA, you do need a quorum for the election. As I mentioned, members have the right to vote in election in person or by proxy unless otherwise set forth in the governing documents. If the governing documents permit voting by absentee ballot, the ballot must be placed in a blank inner envelope with no markings other than saying ballot and mailed or delivered to the association in an outer envelope. The outer envelope has the name of the owner, the lot number, or the lot address, and the signature of the owner casting the ballot. Now, again, that's how I keep saying this. That's how condos vote statutorily by this double envelope secret ballot process. And I see HOAs doing it just, I think, because they think they can, because they see it in condos or whatever. But again, unless your bylaws, governing documents authorize absentee balloting, then there is no absentee balloting. And the votes are cast at the meeting pursuant to the bylaw procedures. So don't assume that you're voting like in a condo, because it's definitely might not be there. All right, next. I think I said that enough times, right? Now, any challenge to an election process must be commenced within 60 days after the election results are announced. So if the association did everything wrong, didn't follow their bylaw procedure, didn't use the right kind of voting procedure, but on the 61st day following the annual meeting, theoretically you've done everything right, because that's the deadline to challenge the election. And where is the election challenge? What is the venue? Well, an election dispute between an owner or member and the association is either submitted to binding arbitration with the Florida Division of Condominiums, Timeshares, and Mobile Homes. It's one of the few things that the division actually has jurisdiction of for HOAs, or filed in court. If you do submit a dispute to the division for arbitration, then it's governed by the Condominium Act arbitration process, which is 718.1255. Next. Now, another option is electronic voting, which is online voting. But you have to follow some procedures to adopt electronic voting for the association. You can use an online voting system for any owner vote, including elections. If an owner provides his or her consent to the online voting, an owner voting electronically is counted towards a quorum. But to adopt online voting, electronic voting, must be established. The board then must basically adopt that process by a board resolution at a board meeting, for which notice has been provided to the owners at least 14 days, written notice at least 14 days prior to the meeting. And that notice of that meeting must be mailed, delivered, or electronically transmitted to those owners who have agreed to electronic transmission. And notice must be posted in the community at least 14 days in advance. So to adopt electronic voting, the board has to adopt a resolution upon this 14-day notice of the board meeting. The board resolution must provide that the owners will receive notice of the opportunity to vote through an online voting system. The resolution must establish reasonable procedures and deadlines for owners to provide their written consent to voting online, and also reasonable procedures and deadlines for owners to opt out. So basically, every time, if you have electronic voting, every time you have an electronic vote, you basically give owners the option to either vote electronically or opt out and vote the, I guess I would say the old-fashioned way, or the non-electronic way, either person, proxy, or whatever the documents provide for. Next. If you're having online voting, or if you've adopted online voting, each owner must be provided with a method to authenticate the owner's identity, a method that's consistent with your documents and your election procedures and the bylaws, a method to confirm at least 14 days before the deadline to vote that your electronic device can successfully communicate with the online system. And the association must have an online system that is able to authenticate the owner's identity, authenticate the validity of each electronic vote, to make sure it's not altered in transit, to transmit a receipt to the owner who cast their vote online, to permanently separate any authentication or identifying information from the electronic election ballot, so it's impossible to tie that election ballot to that owner in order to keep the vote secret, and store and keep electronic votes accessible to election officials for recount, inspection, and review purposes, as well as owners who may want to inspect the election materials later. Next. Yeah, we've talked about the election of board members. Okay. Election of officers. Okay. Under almost every set of bylaws I've ever read, very few exceptions, I think 2, officers are elected generally pursuant to the bylaws by the board. So the board elects the officers, president, treasurer, vice president, et cetera, et cetera. Usually that's done at the organizational meeting immediately following the board meeting. They have to post notice of that meeting. Now, directors cannot vote by proxy or secret ballot, except they can use secret ballots in the election of officers. Board members can never vote by proxy, okay? But they can vote by secret ballot when electing officers. That's the one exception for allowing board members to vote by secret ballot. Also, generally speaking, under most bylaws, the officers serve at the pleasure, or maybe a better word is displeasure, of the board. So generally speaking, under most bylaws that I've ever read, if they want to, the board can change officers midstream. They can't take a director out of his or her seat on the board, okay? But they can take an officer out of his or her seat as an officer or change officers. Again, so they're still board members, assuming they're board members, but they can change officers. If you also see it says there, does the president vote? That question is there because, I've frequently been asked through the years, or I've been told through the years by certain associations, oh, our president only votes to break a tie. Okay. Assuming the president is also a director, that's not the case. This is not like the president of the Senate who votes to break ties under the Constitution. In these corporations, every director votes, okay, including the president. So yes, the president votes. He or she sits as a director, and all directors have equal votes. Right. Next.
And we're on the board of directors slide. Before we continue, just want to remind everybody, some of you are placing questions into the chat. For all course-related questions, the chat is not being monitored for course-related questions. We will open up the Q&A at the end if there's enough time. There's a lot of material in a 2-hour time period. So our experience shows we typically don't have enough time for questions, but the chat is only for technical issues or a question for me that does not require an attorney's answer. Okay. If you have trouble seeing it, viewing it, hearing it, that kind of a thing. So that's why your questions in the chat are not being answered. I just wanted to reiterate that and allow Peter to have a glass of water at the same time. So back to you, sir. We're on the board of directors page.
Thank you, Jeff. Yeah, them be the rules, folks. It's just this kind of format. That's the way we have to do it. Board of directors. Okay. So we're just going to skip this slide because I don't think it's that exciting. And, basically, as I mentioned, directors do not vote by proxy or by secret ballot, except secret ballots can be used for election of officers. Directors can communicate with each other by email, but cannot vote by email. All right. Board members should not be making unilateral decisions, even the president. All right. Like I said, all board members act with an equal vote. And the president, he or she, does not, run the association himself or herself. And decisions are made, by the board as a group. You have a fiduciary responsibility to the owners to act in good faith. Now, must you always be right? No. Okay. Under the reasonable business judgment rule, as long as you're acting in good faith, okay, reasonably and in good faith, then your decisions are not going to be overturned or questioned or expose you to liability. And directors do not always have to be, quote, right, unquote. But you do have to act in a reasonable, prudent manner in good faith. Next, board meeting notices. All board meeting notices must include the date, time, and place of the meeting. You cannot levy an assessment at a board meeting unless a notice includes a statement that assessments will be considered and the nature of the assessments. All right. Now, the same requirements apply to a couple of committees, okay, as they do to boards. So in other words, if a committee has the authority to make a final decision regarding the expenditure of association funds, that's not typical, but if there is such a committee, that committee must post notice and be open just like a board meeting, okay? Or any committee having the power to approve or disapprove architectural control decisions with respect to any owner's lot or parcel, that committee, that architectural control committee, it must post its meeting notices and be open to the members like a board meeting. So those two types of committees have to meet in the same manner as the board with respect to the posting of notice and being open to the membership. Now, typically, board meetings and those couple committees must be noticed for those meetings must be conspicuously posted at least 48 hours in advance of meeting, except in an emergency. And that means a bona fide emergency. That doesn't mean, oh, it's the end of April and everyone's moving back up north. So that's an emergency. That's not an emergency. An emergency would be a bona fide emergency, whether that's under hurricane conditions or something like that. But that type of emergency could obviate the 48-hour notice requirement. Now, there are some instances where you have to post more than 48 hours, 14-day notice. We already mentioned a few of those. Okay, so unless your documents provide otherwise, written notice of any meeting at which special assessments or an amendment to a rule regarding the use of a lot or parcel will be considered must be mailed, delivered, or electronically transmitted to the owners and conspicuously posted on the property at least 14 days prior to the meeting. So this is crucially important with respect to the rule and the special assessments, because if you don't post your meeting notice 14 days in advance and mail it or electronically transmit it 14 days in advance or deliver it 14 days in advance to the owners, then that particular special assessment or rule is not going to be enforceable. And particularly when it comes to collections and things like that of a special assessment. So it's very, very important that you comply with those notice requirements. Next. In addition to any other authorized means of providing notice, you can also, by rule, adopt the procedure for conspicuously posting the notice and the agenda on the association's website, or an app that can be downloaded to a mobile device, i.e. your phone, for at least the minimum period of time for which notice is also required to be physically posted on the property. Any rule adopted must include a requirement that the association send electronic notice to members whose email addresses are included in the association's official records in the same manner as required for notice of the meetings. Again, if you have owners who have agreed in writing to receive their notices by email, this is what that's referring to. And your notice must include a hyperlink on the website or the mobile app. Next. Directors can't be paid. I know, very, very disappointing, right? I'm sure, that's why they call it a thankless job. But directors, officers, or committee members may not directly receive any salary or compensation as a director, officer, or committee member, and may not in any other way benefit financially from service to the board. And there's a couple of exceptions for that. I'm going to exactly call these being compensated, but the exceptions are you can't participate in a financial benefit accruing to all or a significant number of the members as a result of actions lawfully taken. Reimbursement for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval processes, though the board may have to approve those out-of-pocket expenditures. Recovery of insurance proceeds derived from a policy of insurance maintained by the association for the benefit of its members. Now, if the governing documents do authorize payment of a fee or compensation, that's okay. That's pretty rare. Documents provide for that. Or by a vote of majority of the voting interests at a meeting at which a quorum is attained, they can authorize payment. Next. Now, contracts. In other words, if the board entering a contract with a director, that's a conflict of interest. There are ways to do it. Okay, you got to jump through some hoops to enter into a contract with a director or an officer or a company or entity in which the officer, director has a financial interest. Okay. The board must comply with certain requirements to do these. I wouldn't recommend you do this, but if for some reason you feel compelled to do it, then the process to follow is that the contract must be fully disclosed to the board, and the disclosures entered into the minutes of the board meeting at which the proposed contract will be considered and voted upon, and the contract must be approved by 2/3 of the board. It must be reasonable and fair, the contract or the transaction to the association, and at the next regular or special meeting of the membership, okay, the contract or transaction must be disclosed to the members, and upon any member's motion, that they can cancel the contract by a majority vote of those present, again, or by proxy, assuming you have a quorum established. If they do vote to cancel the contract or the transaction, the association is only liable for the reasonable value of the goods and services provided up to that time and is not liable for any kind of liquidated damage or termination fee or other kind of penalty. Next, a director or officer charged by information or indictment with a felony theft. Presumably this will not be applicable to anyone who is watching or listening to this. But if you are just charged, you don't have to be convicted. If you're just charged basically with embezzling, stealing from the association, you are automatically removed from office. That vacancy is filled by the board until the end of the suspension or the end of the director's term, whichever occurs first. If the charges are dismissed, okay, without a finding of guilt, or acceptance of a plea of guilty or nolo contendere, then the officer is reinstated. All right. Anyone who has charges pending against them, again, not conviction, just pending, they can't serve or be appointed to office. Next. You also can't take stuff you're not entitled to. So no kickbacks, no improper benefits, no solicitation for kickbacks or improper benefits. I really shouldn't have to spend too much time on this. Everyone out there obviously knows that that is improper. Okay. You can accept if you go to an educational type thing. For example, if I was teaching this class in person, and there was, I don't know, there was refreshments available, you can consume food and things like that at a business meeting, as long as it's of a value of $25 or less. I'm not sure who's keeping count of that, but anyway, that's what the law says. Or if you go to a trade show, I do a lot of trade shows, and you're taking the stuff off the tables that the vendors are giving away, that's okay too. If the board does find that an officer director has violated this provision, i.e. kickbacks, improper benefits, things like that, then the board shall immediately remove that person from office and the vacancy is filled, okay, period, until the director's term of office is over. Next. A vacancy on the board that occurs, though, on a more typical manner, by expiration of a term of office, then it's filled by election. So at the end of an officer's term, that seat is filled by election. If a vacancy occurs prior to the end of a term because of death or because of resignation or disqualification, i.e. maybe the director doesn't own their home anymore, and these documents require all directors to be members, which, by the way, you have to check your documents for that. Directors do not necessarily have to be owners unless the documents limit it to owners. In those type of vacancies, unless your bylaws provide otherwise, it's filled by a majority of the remaining directors, even if it's less than a quorum or only one director. Okay. So in the case of a death, a resignation, disqualification, because they're no longer eligible, the seat is filled by a majority of the remaining directors, even if less than a quorum. Now, that replacement director, he or she serves for the balance of the seat that they're filling, unless the bylaws provide otherwise. So sometimes you see this with staggered boards where the board members are serving multi-year terms. And sometimes the bylaws will provide that the replacement director who is appointed to fill a vacancy only serves until the next annual meeting, in which case he or she may not theoretically fill out the balance of the term if the person died or resigned, let's say, during the first year of office. If they're only 1 year terms, obviously that wouldn't be the case. So long story short, vacancies occurring this way filled by the board unless otherwise provided, and the replacement director fills the balance of the term unless otherwise provided by the bylaws. Next. Similarly to ownership meetings, board meetings are also open to all members. Okay. There are 2 exceptions. Okay. If the board or the committee is meeting with its attorney with respect to proposed or pending litigation, where the contents of the discussion would otherwise be governed by the attorney-client privilege. Okay. Or you're having a meeting for the purpose of discussing personnel issues, hiring, firing, discipline of employees, that kind of thing. Members have a right to attend all board meetings, except for those 2 I mentioned. And they have a right to speak at any board meeting with respect to all designated items on the agenda or otherwise that are brought up. Now, you can, and you probably should, adopt reasonable rules regarding the frequency, duration, and other manner of member statements, okay, including a sign-up sheet perhaps for members wishing to speak, which you see, for example, with a lot of municipalities and county commissions. Unlike a member's right to speak at members' meeting, there is no statutorily prescribed time limit, although a minimum of 3 minutes is a reasonable rule. So remember, with membership meetings, there's a minimum of 3 minutes to speak. You can adopt that for your board meetings as well, but there's no statutory provision on that like there is with a membership meeting. Next, any owner, okay, and this is the same for a membership meeting, can record audio or video board and membership meetings. You can adopt reasonable rules about that, i.e. can't be walking around the room, can't be disturbing people, It used to be back in the day, they would set up lights and cameras. Now everyone uses their phone, so that isn't really applicable anymore. But basically, reasonable rules that people can record without disturbing the meeting proceedings. Now, those rules can't be unreasonable, though. You can't make someone record the meeting from 200 yards away. So, you got to use common sense and make them reasonable. Board meetings must be held at the location accessible to physically handicapped persons if requested by a physically handicapped person who has a right to attend the meeting. Different from condos, but that's in the HOA law. Next. Committees. Okay, I'm going to skip this slide actually because I find this slide not that interesting. I'm going to go on to the next one. When does a board meeting occur? Okay. A board meeting occurs statutorily when a gathering of a quorum or more of directors to conduct association business. What's conducting association business? It's not defined. Okay. I'll be honest, different lawyers have different opinions on it. Okay. I guess I'm more on the conservative side as opposed to, for lack of it, I don't want to make it like a political discussion, more liberal. But on the conservative side, to me, if you have a quorum or more of board members and you're discussing substantive association matters, not necessarily taking votes, not necessarily passing motions, but if you're substantively discussing association business, to me, that constitutes a board meeting. Again, others have different views. If you're just, together and, you're discussing, non-association matters, obviously that's not a board meeting. Again, this isn't really that, it's not defined in the statute. So I define it, in a pretty conservative manner, because you should strive, if at all possible, to be discussing association business. If you're having a quorum of more, that should be a noticed open board meeting.
Here's another drink water opportunity for you. I understand your point of view there, but I see a lot of names on here that I recognize who have probably heard me say this before. If you're on a board and you want to provide research and information that's accurate and clear and concise to bring to your membership at the next meeting, how is a board supposed to do that without needing to discuss that particular topic? That's where I'm a little confused about the whole thing.
Well, and I think if you're having a board meeting and you're setting your agenda, okay, for your next meeting, I don't think you're conducting association business. You're just setting your agenda. If you're deciding that you want to provide the owner's information, is that what you're saying?
Well, for instance, like a board gets together to discuss association business. They're not making a decision. They're not saying we're going to rubber stamp this or we're going to do this or going to do that. All 7 board members are getting together to discuss a particular item that's going to be voted upon. They have to do the proper research, get the numbers, vet out the vendors, so on and so forth. At some point, they have to meet so that they're all on the same page to when they get to the meeting. So is that still considered?
It depends on the
extent that
it depends. Look, there's no right or wrong here.
Okay.
Kind of like obscenity, you kind of know when you see it. But if they're just basically sharing some information to be on the same page with respect to what are the issues, okay. But if they're going to get into, to me, if they're starting to get into the nitty-gritty of discussing it, so basically, it's all been discussed, and then when they get to the meeting, if they've already discussed it and they're voting, no. I mean, there's no real bright line here.
Yeah.
Okay?
Yeah.
It is gray.
Yeah.
That's why there's 8,000 million lawyers and judges in courtrooms. I wish there was a bright line.
Yeah.
All I'm saying is strive. Again, informational meetings, like for example,
like a town hall,
boards have what they call workshop meetings. And sometimes they do that as a way to hide because they don't want to discuss things in the open.
Right.
So again, I tend to be, like I said before, conservative on this. There are different schools of thought. I'll be the first to admit that. I say you should strive not to get into break up into small groups.
Okay.
Into groups of less than a quorum.
That's a good statement. There you go.
If in doubt, look, no one's going to jail over this. All right. Maybe you, but for asking me the question, but no, it's a good question. I get asked this all the time for the last 30 plus years, more than that, almost 40 years. All I can say is, every now, it's okay to share some information, get yourselves on the same page, but just be careful you're not really doing all your work behind closed doors.
Well, thanks for saying that, because I knew that's where we always get a bunch of questions if we open up the Q&A later. So I just wanted to put that out there right now. So thank you, sir.
You're all going to go to HOA jail.
Back to you.
Do not pass go. All right, next. All right, how to get off the board? According to Solomon, you just got on the board. Now you want to get off because you probably broke all the rules. But there are ways to get off. Recall, talk about that maybe if you have time. Now, if you don't get certified like you're doing this afternoon, we talked about that. We talked about the criminal charges, taking excessive gifts, obviously resignation. Now, if you become more than 90 days delinquent in the payment of any monetary obligation, you've abandoned your office. And that could be an assessment, that could be a fine, basically any monetary obligation that's owed to the association, you're off. Next. Okay, minutes of meetings. Your minutes of meetings should be, as the word implies or says, minute, not verbatim, not every cough, burp, or other bodily noise that occurs at a meeting. I don't even like it, for example, including all the comments, basically the business meaning who was in attendance, either in person or remotely. Okay, we'll talk about that in a minute. What motions were made, who seconded the motion, and how did each director vote? Yes, no, or abstention. That should be the minutes, the business. When people stand up and start waving documents around like, Joe McCarthy from a million years ago, and want you to read something into the minutes, you don't have to read that into the minutes. They can record the meeting, that can be recorded, but as far as the official minutes, people in the audience or even directors cannot demand that letters or other statements be necessarily appended to or made part of the minutes. Now, if you're doing a contract or something like that, yes, that contract that you approve or vote on, that should be part of the minutes, all right, but not these extraneous things. Next. Unlike condominiums, in a condominium association, the association has a right of access to all the units for certain reasons, particularly maintenance of the common elements, maintenance of any part of the unit they're responsible for, or as necessary to prevent damage to the common elements or to a unit. There's no statutory right of access to the parcels or lots or the homes in the Homeowner Association Act. The documents can provide access, okay, and they may grant the association right of access, but there's no statutory right of access. Next. Similarly, material alterations or improvements to common area, Condominium Act, very specific about material alterations to the common elements, which basically has been defined by statute, by case law, not by statute, by case law, to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in a manner as to appreciably affect or influence its function, use, or appearance. In a condominium land, the common elements cannot be materially altered or added to without the vote set forth in the declaration of condominium. Otherwise, you need 3/4 of all the owners to approve, or 3/4 of the voting interests to approve. Chapter 720, the Homeowner Association Act, is silent, okay? Does not talk about material alterations or the vote needed to alter the common area. Therefore, what do we look to? Got to look to the governing documents. You got to try to figure out through the governing documents what approval, if any, is required of the owners to improve, materially alter, improve, or add to the common area. So again, it's completely different. It's not statutory. It's all driven by the association's declaration and other governing documents. Next. Amending your governing documents, okay? Unless otherwise provided, any amendment requires a vote of 2/3 of the voting interest. Typically, though, each document, declaration, articles of bylaws will have an amendatory section, and that amendatory section will set forth the procedure or process to amend that particular document. So you got to, read them and check them out. The format is similar to condominiums now. The two laws are the same. They were not for years and years. Now they are, in that proposed amendments, you're required to underline language is being added, okay? And language is being deleted is shown with hyphens or lines striking it out, okay? However, if the amendments are very extensive, so that's difficult to read or difficult to understand, you can simply put the new language in and state that that you have to have this notation: substantial rewording, see governing documents for current text. So you can use that where the underlining and crossing through will make it difficult to read or comprehend the amendment. As far as mortgagee consent, which you see oftentimes, that you have to get mortgagee consent and under certain documents, to certain amendments. Under the Homeowner Association Act, if mortgagee consent is required, it only applies to mortgages recorded after July 1st, 2013. If after 60 days of no response, the lender is deemed to have consented to the amendment. But read your documents carefully with respect to any kind of mortgagee lender approval requirement. After the declaration or after your governing documents are amended, then within 30 days, you have to send a copy of that to the owners. However, if a copy of the proposed amendment was provided to the members prior to the vote and it was not changed before the vote, you can provide notice to the members that it's been adopted and a copy is available upon written request at no charge to the owner. Next. Leasing restrictions. This is similar, but not the same to the Condo Act. Okay. And this is relatively new for HOAs. As of July 1, 2021, which was just a couple of years ago, any governing document, any governing document or any amendment to a declaration that prohibits or regulates rental agreements applies only to an owner who acquires title to their parcel or lot after the effective date, which meaning after it's been recorded, or an owner who consents individually or through a representative to the amendment. So leasing restrictions affecting renting or rental agreements apply to owners who acquire afterwards or those who vote in favor of it. However, there are some exceptions. Unlike in the condominium law, there are exceptions in the HOA law to the applicability of the leasing amendments. An association may amend its governing documents to prohibit or regulate rental agreements for a term of less than 6 months and may prohibit the rental of a parcel for more than 3 times in the calendar year. And those amendments will apply to all owners. So we won't have the grandfathering in essence. So I'll say it again. We have the grandfathering provision, but if you're amending your declaration to basically prohibit leasing for less than 6 months or prohibiting rental for more than 3 times in a calendar year, those apply to everyone. Also, the rental restrictions do not apply to associations with 15 or fewer owners. Now, we mentioned before that it applies to new owners, right? However, there's an exception to that. Okay. What is a change of ownership? A change of ownership does not occur where the beneficial interest or ownership of the parcel does not change, or when an heir becomes the owner, or when the owner conveys the parcel to an affiliated entity. All right. These are for lots or parcels that are owned by entities, whether it's a corporation or an LLC. An affiliated entity means an entity that controls, is controlled by, or is under common control with the owner, or that becomes a part of a successor entity by reason of transfer, merger, consolidation, public offering, reorganization. In other words, this was basically pushed through by these large entities that own thousands, not millions of properties throughout the country and a lot in Florida. They didn't want to be subject to these restrictions. So they had this affiliate entity language basically pushed through. So when they transfer to an affiliate entity, that's not the change of an ownership. Under the rental amendment restrictions, a change of ownership does occur when, with respect to an owner that is a business entity, every person that owns an interest in the real property at the time of the enactment of the amendment or rule conveys their interest to an unaffiliated entity. Okay, next. We mentioned rules and regulations. Now, rules and regulations, although they're the caboose in terms of the hierarchy, they are enforceable if done properly. So the association through the board will check your documents to see whether you also might need owner approval, because some documents require owner approval in addition to board approval. If they don't, then typically, most documents provide that the association through the board may promulgate reasonable rules and regulations or amending rules and regulations pertaining to the use of the common area, the recreation facilities, and to the use of the lots. Again, if your documents so provide. I've read many HOA documents, though, that for whatever reason say the board can adopt rules and regulations regarding the use of the common area. And that's all it says. which in that case means you cannot adopt rules regarding use of the lots or the parcels, but only the common area. Now, if it says you can adopt rules regarding the use of the common area and the lots, obviously then you can. So you got to check and see what is the rulemaking authority, if any, of the board. And we already mentioned that. That's the second bullet point there. Now, for a brief period of time, the statute was amended to provide that governing documents which must be recorded include the rules. However, that was amended out. So unless your documents require the rules to be recorded, they're not required to be recorded. Which again, you got to check your documents on that. Parcel use rules, as we mentioned several slides ago, written notice of any meeting at which the board will consider the adoption or amendment of a rule regarding the use of a parcel, i.e. the lot and or the home, okay, owned by an owner. Then that type of rule, the notice of that meeting must be mailed, delivered, or electronically transmitted to all owners and posted conspicuously on the property at least 14 days prior to the meeting when you're going to adopt or amend that type of rule. Other rules, unless the documents provide otherwise, only need a 48-hour meeting notice for adopting those rules regarding use of, let's say, the common area or the recreation facilities. Now, for any rule, let's see if it's the next slide or not. Now I'm going to go back. I'll stay on the rule. Any rule, in order to be enforceable, number one, you need to have the authority to enact it, as we just talked about. Number two, the rule must be reasonable. Okay, what does reasonable mean? Basically, under case law, it means rationally related to the promotion of the health, safety, or welfare of the owners or the protection of the property. Also, for a rule to be enforceable, it cannot conflict with any express provision of your declaration or any right that's reasonably inferable from your declaration. So if your declaration, for example, addresses vehicles, then if you're going to change the vehicle restrictions, you need to amend the declaration, not adopt the rule. So again, must be reasonable, must be properly adopted, and cannot conflict with any express provision of your declaration or any right that's inferable from your declaration. Okay, now we'll move on. Marketable Record Title Act. This is unique to homeowner associations, does not apply to condominium associations, because this is a title issue and dealing with whether or not the declaration, it basically shows up in the chain of title to the lots in a condominium. Why condominiums don't have to be concerned about the MARTA or the Marketable Record Title Act is because legally in a condominium, the legal description of every unit includes a reference to the declaration of condominium where it was recorded, the official record book and page. That's part of the legal description of a condominium unit. It's not legally required to describe, though, a lot or a parcel in an HOA. So typically the legal description of a lot or a parcel in an HOA will be reference to the plat that subdivided the property. So it'll say lot, 15 block 4 in the Happy Acre PUD pursuant to plat number, whatever, page number, whatever of the plat in the public records, no reference to the declaration. So under Florida law, if a declaration becomes more than 30 years old, okay, with respect to the root of title to the lots, then it's extinguished or it expires or it's no more unless it gets preserved. Okay, so you have to preserve it. Generally used that 30-year period. So the declaration needs to be preserved, before it becomes, 30 years old, in order not to, in essence, expire because of the Marketable Record Title Act, because it's not showing up in the chain of title, unlike a condominium declaration. Trying to make that relatively clear. So there's a few ways to preserve a declaration and the exhibits to it, articles and bylaws, by written notice under 712.06, a summary notice under 720.303(2), subsection 2, or an amendment to the declaration which references the reporting information as of October 1st, 2018. If it's not preserved, then it can be, you must revitalize it. And the revitalization process is pretty involved, requires a vote of the owners. Preservation only requires action by the board. So since we have a time constraint here, I can't go into tremendous detail. I think the next slide or two has some more detail. But just be aware that, if you're inching towards that 30-year mark for your declaration, please take steps to preserve it. Okay. Also, and they amended Chapter 720 in 2018 to say that the first board meeting, excluding the organizational meeting, which follows the annual meeting, the board is required to consider the desirability of filing notices to preserve the covenants or restrictions affecting the community or association from extinguishment under MARTA. I'm not sure what the penalty for not having this meeting is. I think it's mostly just a reminder to associations that, to keep MARTA in their forefront of their thoughts. Next. A gated community must allow unannounced entries for process servers, including the common areas where the process server is attempting to serve process on a defendant or a witness who lives in the community or is known to be within the community. Since these process servers, sometimes they are law enforcement officers, but they're also considered officers of the court, even the private ones. So you cannot, to use a double negative, you cannot not let them in. In other words, you must allow them access to the property to serve or attempt to serve their process. Next. Do you have to have a licensed manager? No, but under certain circumstances, then your manager must be licensed. Okay, so community association management under section 468.431 through 438, certain services, certain functions require licensed managerial skill, and there's a list of them there: controlling or dispersing funds, preparing budgets or other financial documents, assisting in the noticing or conduct of community association meetings, coordinating the maintenance of the day-to-day services involved in the operation. Now, if they're providing these services and they're being paid, he or she or the company is being paid, and the association has more than 10 units or a budget that exceeds $100,000, then that person must be licensed as a licensed community association manager, otherwise known as a CAM. Okay, so the community association doesn't necessarily have to have a licensed manager. You can be self-managed through the board, but if you're more than 10 units or have a budget of more than $100,000 and you're paying one to do these services, that person or that company must be licensed. Next. A community association manager basically must perform his or her duties or their duties loyally, skillfully, honestly, in good faith, cannot charge unreasonable or excessive fees. Now, management contracts frequently have indemnity clauses. I'm not going to get into the pros and cons of all that right now, but typically they will ask the association to indemnify them. You have to read these carefully, go through them with your counsel as to the language that you may or may not accept. However, at a minimum, they cannot require that you indemnify them for violations of criminal law, impersonal benefits, improper benefits, acts that are grossly negligent, reckless, bad faith, malicious, wanton, and willful. So these things they cannot be indemnified for. You cannot, or they cannot require that you indemnify them. I will say this: that the indemnity provisions in these management contracts typically are pretty heavily negotiated, not always, but frequently they are. Next. I'm going to go by the construction defects. Only thing I'm going to mention of that is that there are some warranties with respect to common areas to the extent that they are supporting the home. But I want to move on to some more important things that I think are the emergency powers. I'll try to touch on relatively quickly. This was all an offshoot, really, from the COVID emergency that we went through a few years ago. Basically, under Chapter 723.16, it provides that an association board has certain emergency powers. Now, originally, that pretty much applied to the hurricane situation. When we had the COVID emergency, everything got turned upside down. So they amended the statute to try to address that type of emergency situation as well. So basically, under the statute, An HOA through the board can perform certain actions in the event of a state of emergency. And that's basically when the governor has declared a state of emergency for the area in which your association is located. Okay. In 2021, which was the post-COVID, these powers were clarified and expanded so they can be applied to basically the COVID emergency. So among other things, what you can do in an emergency, or if there is an emergency, a situation, you can designate assistant officers who are not directors to step into the shoes of an officer in the event the officer is incapacitated or unavailable. In addition to conducting, canceling, or rescheduling association meetings and providing notice in said meeting as a practical way as possible. All those meetings may also be conducted in whole or part by telephone, real-time video conferencing, or similar real-time electronic or video communication. Obviously, this is addressing what we went through when everyone became in love with what we're doing right now, a Zoom type of meeting under those, under those circumstances when we could not gather in person. So basically codified in certain types of emergency, being able to have those type of meetings. Next. What else can you do under emergency? Well, you can mitigate further damage, including the removal of, debris and wet drywall and cabinets or things like that, and mitigate the spread of fungus or contagion, or to sanitize the common property. Obviously, another COVID-related thing. Emergency plans can now be implemented in addition to the disaster plan before, during, or following the event for which the state of emergency is declared, including but not limited to shutting down elevators, electricity, water, sewers, or security systems, or air conditioners. You can determine if any property or any portion of the property is unavailable for entry or occupancy, or if the property or any portion of the property can be safely inhabited or occupied based on the advice of emergency management officials or licensed professionals hired by the board. Next slide. In addition to making decisions regarding whether the property is available or unavailable for entry and occupancy by owners or their family members or tenants, etc., in order to protect the health, safety, or welfare of such persons, upon the advice of emergency management officials or licensed professional retained by the board, you can also get that advice provided by public health officials or other licensed professionals available to the board. This was the change made to address when the CDC or the local health department is also issuing advisories. So that was expanded to include those type of entities as well. Next. Okay. Notwithstanding the power of the board in an emergency to prohibit access to the property, the association cannot or may not prohibit owners, tenants, guests, agents, or invitees of an owner from accessing the common area and the facilities for purposes of ingress to and egress from, when necessary, connection with the sale, lease, or other transfer of the parcel, or the habitability of the parcel, or for the health and safety of such a person, unless a governmental order or determination or a public health directive from the Centers for Disease Control, the CDC, has been issued prohibiting such access to the parcel. So basically, although you can control access, you cannot basically prevent someone, from going back and forth to their home in connection with sale, lease, or the habitability, or the living ability or habitability of that parcel, unless the CDC or someone else with authority is making the determination. Next. Okay. In order to exercise the emergency powers, remember, all these emergency powers are with respect to, again, if a state of emergency has been declared for the area in which the homeowner association is located. In order to exercise these powers, the board may, without a vote, levy special assessments and borrow money using the association's assets for its collateral to fund repairs to carry out the association's business in the event the operating funds are not enough. These emergency powers are only available to the board for a period of time that is reasonably necessary to mitigate further damage and make repairs and to protect the health, safety, and welfare of the community and the residents of the community. Mini water break. Okay. I'm going to skip the driver's license thing. Just be aware that as far as swiping driver's licenses at the gate, It's not permitted except for limited purposes. I said I was going to skip it, and I'm talking about it. But it's limited as to when you can do that. So I'm going to go on to budgets and special assessments and reserves. Once the board has prepared the proposed budget, it is typically adopted by the board. Okay. The governing documents, you have to review them for any specific notice requirements, because unlike Condominium Act, HOA Act, not really specific about the notice requirements for your budget meeting. Okay. Other than if you're going to be adopting assessments or considering assessments, they have to be on the agenda. Okay. Condominium Act, though, it's a 14-day minimum requirement for a budget meeting. HOA law doesn't say that, but check your bylaws out to see what they do say about any specific notice requirements for your budget adoption meeting. Okay, if they're silent, okay, and the budget is to be approved by the board, then a notice of the board meeting can really only has to be posted 48 hours in advance. But you have to indicate on there that you're going to be considering the adoption of the budget. Excuse me. As I mentioned before, non-emergency special assessments is a 14-day notice sent to the owners and posted 14 days in advance. Okay, next. Unless the documents require the board to provide a copy of the proposed budget prior to the meeting, you're not required to do so. But as a matter of course, you should consider doing it. But unlike condominiums, you're not required to do it unless your documents require you to do it. Okay. Now, under 720.3036, once the budget has been adopted, the law does require that you provide each member with a copy of the budget or written notice that it's available at no charge. Okay. If it is requested, then a copy of the adopted budget must be provided to the member within a time frame set forth for inspection of official records, which is 10 business days after receipt of the written request. So you don't have to send it to the owners before the budget meeting unless your documents require you to, although you may want to. But after it is adopted, you do have to send the budget to the owners or give them notice that it's available at no charge upon request. All right, next. Each year, you must prepare a budget that sets forth the proposed expenditures for the maintenance, management, and operation of the community. The budget is adopted for a 12 or 1 year period, 1 fiscal year, and must reflect the estimated revenues and expenses for the year that the association believes will be incurred, as well as any estimated surplus or deficits. Probably usually always use last year's budget as kind of a template, but obviously if you have expenses are coming up, those must be included in your proposed budget for the next year. Now, your operating budget, just like condos, they're really not locked into those line items. You have to show them in line item, but they're not locked into those line items. Now, there's 2 aspects to every budget, but these is vastly different than condos, and that's why I want to talk about this. You have an operating and reserves, maybe for the reserves, okay? For the budget for each association must state the estimated common operating expenses on an annual basis, that must have the beginning and ending date of the budget period, the total assessments to be paid by every parcel or every lot on a monthly or other basis, maybe quarterly, pursuant to your documents. Disclose separately all fees and charges paid for recreational amenities, if any separate fees or charges, and include reserves for capital expenditures and deferred maintenance if they were approved by a majority of the total voting interest. It's no longer required if established by the developer. Basically, for reserves under the HOA Act, for them to be what we call statutory reserves, they must be voted in by the membership. Now, this is completely different than condominiums. In a condominium, every association must budget for reserves. Okay. There's a whole new thing about reserves for condominiums now, the structural integrity reserve study, but I heard talk about that this afternoon. But HOA is completely different in that the HOA, as I said before, in order for them to have statutory required reserves, the membership must basically approve or vote them in. Let's move on. These are the operating expenses on slide 78. And basically, they're the cost of operating association, administration, management fees, maintenance, those kind of things, taxes, insurance. Next, reserves. Now, reserves are for deferred costs, either replacement or deferred maintenance, things that will not be done on an annual basis, and there's less frequently than annually. Maybe lots of different things can be in that category, whether it's pavement resurfacing, repairs, improvements to common areas such as replacement of the roof on a clubhouse, or painting of the clubhouse, things like that, sidewalk, those kind of things. Those can be under the reserves. Now, when the developer is in control, so the next slide, when the developer is in control of the association, slide 80, he or she or it, they can, but are not required to include reserves in the budget. Again, totally, completely different from condominiums. If the developer does include reserves, they can determine the amount of what those reserves are. However, the developer doesn't even have to pay them as long as the developer is paying what's known as the deficit of the association. However, as I mentioned before, the membership can vote in or create reserves. So under 718.303 subsection 6, reserves may be created upon the affirmative approval of majority of the total voting interest of the association. That approval must state that reserve accounts must be provided for in the budget and must designate the components or the items for which the reserve accounts are established. Upon approval by the membership, the board may then include the required reserve accounts in the budget for the next fiscal year following the year the membership votes in the reserves. Once established by the membership, statutory reserves must be funded, maintained, or waived in the manner provided by the statute. Again, any other reserves, so any board-created reserves, are not subject to those restrictions. So if a board establishes reserves for certain purposes, the board can change those, take them out of reserves. Totally different than condominiums. In a condominium context, once reserves are created, they are reserves and they can't be moved around, or they can't be changed without a vote of the membership. In a HOA context, the only reserves subject to those restrictions are those voted in by the members or membership created reserves. Next. The amount to be reserved, is based upon, again, statutory reserves, is based upon the estimated remaining useful life and the estimated replacement cost or deferred maintenance for each reserve item. The association may adjust reserve assessments annually to take into account any changes in the estimated cost or useful life of an item. Funding formulas for statutory reserves must be based on a separate analysis of each of the required assets or a pooled analysis of two or more. Again, statutory reserves in an HOA, those approved or created by the membership, by the owners. Unless the association maintains a pooled account, meaning two or more items in a pool, the reserve schedule should include each reserve account for capital expenditures and deferred maintenance as a separate line item with the minimum disclosures. The total estimated useful life, the estimated remaining useful life of the asset, the estimated replacement or deferred maintenance expense of the asset, and the estimated fund balance as the beginning of the period for which the budget will be in effect. Next. In a statutory reserve situation, reserve funds, any interest accruing shall remain in the reserve account and only be used for purposes unless their use for other purposes is approved by a majority at a meeting in which a quorum is present. Okay. In a pool, you can use anything that's in the pool, for those pool's purposes, and funds can be withdrawn to pay for any items that are in the pool. The difference between an individual reserve account or line item and a pooled account is that instead of each individual reserve account having its own fund balance that can only be used for that item, the money in a pooled account can be used for any of the items that are in the pool. But again, for the 16th time, unless they're statutorily created reserves, all of this can be changed by the board. That's why we have on this next slide, on slide 83, after one or more reserve accounts have been established by the membership, ignore the line there about to the developer, by the membership, proposed budget must include the statutorily defined reserves The association must fund those reserves unless a majority of the interest present at a meeting and person by proxy vote to use them for other purposes, and must include them. The vote to waive was only applicable for the budget year the vote was taken, and whether to submit that vote to the membership is determined by the board. If reserves have been established by the membership pursuant to statute, they may only be terminated upon the vote of majority of all the voting interests, not just a quorum, but all the voting interests. So again, it's completely different from the condominium realm. All of these statutorily reserved limitations in terms of funding and how they're used, again, is only if the membership has voted in to create these reserves. Otherwise, the board has discretion. Okay. We talked about special assessments. Basically, when you do that, the special assessment meeting is a 14-day notice. The notice must include that you're going to adopt the special assessment and the nature and the purpose and the amount of the special assessment or the cost of the assessment. Once it's been adopted, you must send, or you should send, a notice to all the owners of the adopted and allow the owners a time in which to pay. Unless your documents have a specified time, then obviously you have to follow your documents for the time period. And a special assessment is collected in the same manner as regular periodic assessments. Next. Now we're going to talk about financial reporting. This is your annual financial reporting. Every year, you're required to prepare and complete, or have someone prepare or complete for the association, a financial report with respect to the preceding fiscal year within 90 days after the end of the fiscal year, or annually on such date provided in the bylaws. Within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the board must provide each member with a copy of the financial report or written notice that a copy of the report is available upon request. Since we're now at the end of April, the annual financial report should have been prepared with respect to 2022, since we're in the time of year now for the end of year financial reports, assuming that you use a fiscal year, a calendar fiscal year, which ended in December 31st of 2022. Now, what type of report do you have to do? Well, it depends on your revenues and depends on your documents. If your documents require you to do an audit, then do an audit. Otherwise, it depends upon your annual revenues. Okay, so if your annual revenues were 150,000 up to less than 300,000, it's a compilation. If your annual revenues are at least 300 but less than 500, it's review. And if it's $500,000 or more in annual revenue, then it's an audit. Okay, if it's less than 150,000, you're only required to do a report of cash receipts and expenditures, again, subject to provisions of your bylaws and/or declaration. Next. Now, the board can decide to do a greater, in other words, you might be in the review level of annual revenue. The board can decide it wants to do an audit. Or if a majority of the voting interests approve raising the level, the board must amend the budget. So in other words, the owners can petition and say, we want a greater review. If they do, and if a majority of the voting interest of the membership approves raising the level of reporting to a higher level, then the board must amend the budget or adopt a special assessment to pay for that higher level of financial report. Quite frankly, I've never seen it happen, but theoretically it is possible. If 20% of the owners petition the board to increase the level from that which is required by statute for the fiscal year, then the board must notice and hold a membership meeting within 30 days of receipt of the petition. The level of financial reporting may be reduced. In other words, you can go from an audit down to review or a compilation, or go from review to a compilation. So you can reduce the level if only if it's approved by a majority of the voting interest present at a duly called meeting of the membership. So that's a majority of a quorum. Again, voting in person or by proxy, unless your documents do not allow for proxy voting. Next. If your budget does not include reserves created by membership approval or the declaration or article bylaws do not obligate, okay, I'm going to skip that. And the association is responsible for the repair and maintenance of capital improvements that may result in a special assessment. If reserves are not provided or fully funded, then your report must have a certain disclosure as to why you're not, or the fact that you're not maintaining reserves. This is the disclosure language. I'm not going to read it, but just be aware that if you're not maintaining statutory reserves, because your owners have not basically voted it in, then you have a disclosure in your financial report. If you do have discretionary reserves, in other words, if you don't have statutory reserves, but you have discretionary reserves, there's a different disclosure language, which is also shown there on the screen. So I'm not going to read right now. Next. You have 2 government filings. You have to file your corporate status. Actually, the deadline is approaching. Basically, that's your report with the Division of Corporations, which report of your officers, directors, and your registered agent, principal office and mailing address. And also, you do have to file annual tax returns. Again, like I said before, you are not tax exempt. You're not for profit, which is not the same thing. Bidding, and this is also a difference in contracts, and there's a difference between this and condos, which I think is important to point out. Contracts entered into slide 93. Contracts must be in writing. They cannot be fully performed within 1 year. And if it's a service, I suggest though that basically all your contracts be in writing, whether required to or not. All written contracts for the operation and management must specify or should specify the obligations of the parties, the cost, the frequency that the services will be performed, and the personnel, the number of personnel to be employed to provide the services. Next slide. Bidding. This is very important. If the aggregate cost of a contract is more than 10% of your total annual budget, including any reserves, you must obtain competitive bids. For condominiums, by the way, it's 5%. Okay. The cost of the contract must be more than 5% of the budget. For HOAs, though, if the contract is more than 10%, you're not obligated to accept or take the lowest bid. Oftentimes, you don't want to take the lowest bid. Now, there are some exceptions. You're not required to solicit bids, to obtain bids in the event of an emergency. Okay, but again, must be a bona fide emergency, not just a contrived emergency. You're also not required to obtain bids if for products or services where there's only one provider within the county in which the association is located. Okay, and there are certain types of contracts on the next slide that are exempt from the bidding. Slide 95. These items are not required to be bid. Employees, attorney, accountant, architect, manager, engineer, landscape architect. Doesn't mean you can't get bids for those services, and you probably should, to the extent they are biddable, but you're not required to. However, they must be, and the contracts must be in writing. A contract with a manager, if made by competitive bid, may be made for up to 3 years. Next slide. If a contract was awarded under the competitive bid process or procedures, any renewal of that contract is not subject to the bid process if the contract contains a provision that allows the association to cancel it on 30 days notice without cause. Okay. An association whose declaration of bylaws provides for competitive bidding of services may operate under those provisions in lieu of the statute, as long as those provisions are not less stringent than the statutory requirements for bidding. Next. Communication services. This is basically, we're talking about bulk cable or bulk satellite services. Contracts for bulk communication or internet are deemed operating expenses to be allocated on a per lot or per parcel basis rather than a percentage basis if your documents have a percentage basis, even if documents provide for other than equal sharing. Most HOA documents are equal, but not all. Okay. Any contract entered into before July 1 of 2011, in which the services are not equally divided among the parcels or among the lots, may be changed that way to allocate them equally by a majority vote of the owners present at a regular special meeting of the association, the voting interests. Interestingly, and this is the same as condominiums, any contract for communication, information, or internet services, which would include bulk cable, entered into by the board may be canceled by a majority of the voting interest present at the next regular or special meeting of the association, whichever occurs first. Any owner can make a motion to cancel the contract. If no motion is made, or if the motion fails to get the vote, then the contract is deemed ratified. Quite frankly, though this has been a law for HOAs and condos for a fairly long time, I've never seen it occur, but just be aware of this potential cancellation. Any contract made by the board for, these services, bulk, internet, TV, must provide and shall be deemed to provide that a hearing impaired or legally vision impaired blind owner who does not occupy the parcel with a non-hearing person, with a non-hearing impaired or sighted person, or anyone who gets supplementary security income under Social Security Act or food assistance, they can discontinue the service. In other words, these people can opt out of the services and may not be charged for it and may not be charged disconnection fees for these services. Next slide. A resident of any parcel or lot may not be denied access to available franchise license or certified cable or video service if the resident pays. So if I want to get a different type of franchise service or an additional franchise service, not different. I have to pay for the bulk one the association's getting, but if I wanted another one that's available, that's franchised, the association cannot prevent or stop me from getting that service. And you can't make me pay any additional charges or fees to get this other service. Next. Okay, now we're going to discuss use rights and voting suspensions and fining. And I think I may end it after here, but let's see how far we get. Okay. Okay, the authority to fine and impose suspension of use rights for non-monetary violations. The association has the authority to do that, notwithstanding whether governing documents provide it or not, because it's statutorily they can do it. So it doesn't have to be set forth in the documents. To impose a fine or suspension of use rights for a non-monetary violation, basically the board imposes the fine, imposes a suspension. The owner or other interest or other party other party gets written notice of the violation, an opportunity to attend a hearing about the violation within 14 days of the date of the notice. The hearing must be held before a committee of at least 3 members appointed by the board who are not the officers, directors, or employees of the association, or the spouse, parent, child, brother, sister of an officer, director, or employee. Now, the role of the committee is limited. You call it a fining committee, grievance committee, whatever you want to call this committee. The role of the committee is limited to determine whether to confirm or reject the fine or use right suspension levied by the board. If the committee does not confirm the fine or suspension, it cannot be imposed, exactly as the board imposed it. So the committee is like a little appellate body. Now, for a homeowner association, a fine may not exceed $100 per violation unless otherwise provided by the governing documents. Now, for a condo, a fine cannot exceed $100, period. The documents can't exceed that. In a homeowner association context, the governing documents can actually allow a fine in greater than $100. Okay. Now, for a continuing violation, you can levy a fine on a per day with a single notice and a single opportunity hearing. It cannot exceed $1,000, okay, for a continuing violation. Again, but the governing documents can provide otherwise, cannot for a condo. For a condo, the $100 per violation and $1,000 for a continuing violation are set. HOA, you can exceed it if your documents allow. Also, a fine of $1,000 or more may become a lien against the parcel and collected through the lien process and foreclosure process if the authority to do so is provided in your declaration. Another contrast with the condominium law is that condominiums cannot lien for fines, period. A homeowner association can if your documents so permit, and if the fine is $1,000 or more. Usually that would be for a continuing violation, typically. Okay. A fine payment, notwithstanding the whole lien authority, is due 5 days after the date the committee meeting at which the fine is approved, and you send notice to the owner that the fine is due. Now, That's for suspensions, for fines and suspensions for non-monetary. Next slide, 102. Use right. The board can impose a use right suspension, in other words, suspend your right of use for failing to pay monetary obligations that are greater than 90 days due. The board can do this at a board meeting, but it has to be done at a properly noticed board meeting. The motion can be done one time if properly done at a properly noticed board meeting. My issue with suspensions typically is that they're hard to enforce as a practical matter. Because the practical matter, usually, unless you have a fob system or some system to maybe prevent someone from using the common area, this is something where typically the police are not going to enforce it because it's a civil matter. So you do have the right to suspend for non-payment of the use rights. Same thing with the suspension rights for non-monetary, which is done through the committee hearing. But in my humble opinion, it sometimes are difficult to enforce just because of the practicalities. Now, finally, we'll talk about voting suspensions for failure to pay monetary obligations. The issue here is you can suspend the board then, not through the committee. The board can suspend someone's voting rights who was more than 90 days delinquent. However, the statute was amended in July of 2011 to basically authorize this voting rights suspension. A couple hours ago, we talked about the Kaufman law and the Kaufman case, and the idea that substantive rights, you can't impair substantive rights. Long story short, if you have a declaration recorded before July 1, 2011, and it does not authorize the suspension of voting rights, you likely cannot do it unless you amend your declaration or unless your declaration provides that it's subject to Chapter 720 as amended from time to time, because voting rights are a substantive right. And under a case dealing with condominiums, which we think is applicable to HOAs as well, in that you cannot suspend someone's voting rights for non-payment, again, unless the documents were recorded after the act became effective, which in this case is July 2011, or the documents basically provide that those provisions are incorporated within the declaration because it says they're subject to Chapter 720 as amended from time to time. I know that concept's a little bit difficult, but there's no retroactive, basically, impairment of someone's voting rights. As I mentioned, that's through board action, but you got to be careful that it's not. You have to be careful in terms of when declaration was recorded.
So I've got slide number 105 back on the screen for you.
All right, skip ahead to 115.
You got it. Boom, 115. Official
record.
record.
Last thing I'm going to talk about, I can hear the cheering through my computer, is official records, only because this is something that does come up pretty frequently in terms of official records, what you're required to maintain and what owners are entitled to obtain in terms of access and copying. So I'll talk about official records and then I'll release you for the rest of your day. So the official records. Now we're on slide 116. The official records of the association, there's a laundry list or a list right there. It's basically the plans, specifications, warranties related to the improvements, your governing documents, declaration, bylaws, articles, rules, and the amendments, the minutes of the meetings, that's board, board and owner meetings, copies of insurance policies. I'm going to, all this information that you see there, contracts, financial and accounting records, very important. Roster of all your members, including their mailing addresses and parcel IDs. And interestingly, email addresses are privileged and not accessible, except for those members who have consented in writing to receive their notices by email. If a member or members have agreed to receive their notices of meetings by electronic transmission, then their email address is accessible to other owners as an official record. Otherwise, it's not. All your director certificates that were talked about today, the certifications, and anything else, all the written records, otherwise identified relating to the association business or operations are official records, which must be kept for at least 7 years unless otherwise provided. So moving on, next slide. Effective a couple of years ago, the official records also are comprised of the ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by owners at meetings or otherwise, or by written consent. And they must be kept for at least 1 year. All affirmative acknowledgements, which we're not going to get to, but affirmative acknowledgements means that when you change your method of sending out invoices from either regular mail to email or vice versa, owner must acknowledge that change for themselves or himself or herself, and those acknowledgements are official records, although they're not accessible to other owners. Okay. The records which are not accessible, starting on 118.
Slide 118, yeah.
Yeah, it's slow. Okay, not accessible. Attorney-client, okay, or work product privilege regarding to litigation. Attorney-client, we'll talk about in a second. Work product, talk about in a second. Medical records of owners or residents. By the way, in my opinion, medical records would include those letters you get from owners, healthcare providers about whether or not they need an emotional support animal or a service animal. Okay, so medical records of owners or residents. Information obtained in connection with approval of a lease, sale, or other transfer of a parcel. Personnel records of association or management company employees. Any electronic security measures that's used to safeguard your data, and the association software and operating systems, which allows the manipulation of the data, even if the owner has the same kind of software. These are all not accessible. There's some other not accessible on the next slide.
Okay, 119.
Okay. Personal identification information, such as driver's license, credit card, fax, telephone, social security. I mentioned email addresses before. Emergency contact information, or any address for an owner other than is provided for association notice requirements, and all other personal identification information, excluding the person's name, lot address or lot designation, and property address. These other things are not accessible. I mentioned before that email addresses provided for purposes of providing notice to an owner is accessible, though. Information an association obtains in a gated community in connection with guest visits to parcel owners or community residents is not accessible. Next. Attorney-client. Any record protected by the lawyer-client or attorney-client privilege. Basically, what's that? Anything the attorney sends to you or that you send to the attorney, whether it's by email, letter, facsimile, whatever. Now, any work product privilege. Work product privilege means any record that's prepared by an attorney or prepared at the attorney's express direction, which contains their mental impression, conclusion, strategy, or legal theory, and which prepared exclusively for civil or criminal litigation, or which was prepared in anticipation of such litigation or proceedings until the conclusion. So that's things that could be a lot of different things. That could be certain types of engineering reports or other type of reports or things that are been prepared in anticipation or for litigation. They're privileged until the conclusion of that litigation. Again, the stuff going back and forth directly between the attorney and the client, that's privilege. The lawyer cannot waive that privilege. Only the client or only the association through the board can waive that privilege. I wouldn't recommend it be waived, but they can waive it, we cannot. Okay, the directory. You are allowed to print and distribute to owners a directory with the name, address, and telephone numbers of all your owners, okay? Not email addresses, telephone numbers. However, an owner can exclude their telephone number from being listed in the directory by requesting in writing to the association that his or her phone number be excluded. The association is not liable for disclosure of protected information if it's included in an official record and is voluntarily provided by an owner and not requested by the association. However, an owner can also provide their written consent to disclosure of what is otherwise protected information. Okay. Next. You must make the records available for inspection and copying, including copying with a portable device like a smartphone or a tablet, by a member or their authorized agent at reasonable times within 45 miles of the community or within the county, and when within 10 business days after receipt of a written request for access to the records. Now, you don't have to copy the records and mail them to them and make them available to them, but you have to make the records available, accessible to them to inspect and obtain copies of. Okay. If a request is submitted by certified mail, return receipt requested, and the records are not produced on a timely matter, it creates a rebuttable presumption that the association willfully failed to disclose the records. Now you may have a copy of the official records available for inspection. Again, at the community, you can make them at your option available electronically via the internet, and may allow the records to be viewed in an electronic format on a computer screen and printed upon request. These are all options for the association to take as far as how they're going to provide access to the records. Next.
Yeah.
You can adopt, and I'm almost done, and I would recommend you adopt reasonable written rules regarding the frequency, time, location, notice, the records to be inspected, and the manner of inspection. But you cannot require an owner to show a proper purpose for inspecting the records or any reason for the inspection, or limit an owner's right to inspect to less than 1 8-hour business day per month. You can charge a fee, 25 cents a page, for copies made on the association's copier, If you don't have a copier at the place where the records are maintained, or if the records are 25 or more than 25 pages, you can have them sent out to a duplicating or a copy service, and then you can charge the actual cost that the association is charged by the copy service. You can charge for the costs required for personnel to retrieve and copy the records if the time spent is more than a half an hour and the personnel costs do not exceed $20 per hour. However, you cannot charge personnel for records requested in the copying of 25 or fewer pages. If you have a photocopier available where the records are maintained, you must provide the owner's copies on request. You can only charge 25 cents a page, like I mentioned before. And if the entire request is limited to no more than 25 pages, otherwise you can send them out. An association must allow a member or the representative to use a portable device, such as a smartphone or a tablet or a scanner, or any other technology capable of scanning or photographing the records. You cannot charge an owner or the representative for using those devices to basically copy or photograph the records. If you fail to timely provide them or give access to them, better wording, if you fail to timely provide access within 10 business days, it creates a rebuttable presumption that you willfully fail to it. The penalties are the actual damages that someone's incurred, or minimum damages of $50 a day, up to 10 days, or $500. That calculation starts on the 11th business day after receipt of the written request, since you're required to provide access within 10 business days of receipt of the request to inspect the records. Okay, now I'm finished. I just wanted to get that out because I know records do come up a lot. I know it was a long presentation. I appreciate everyone listening.